Welcome to Just Wanna Quilt, a research podcast coming out of Tulane University Law School, where we explore all kinds of things, stories about quilting, tools, field trips, maybe some famous quilters stop by, and, of course, a little bit of copyright thrown in just for fun. I'm Elizabeth Townsend Guard. I'm a law professor at Tulane University Law School, and I just want to quilt. So today's guest is a colleague and a friend, Ann Bartow. She is a professor of law and the director of the Franklin Pierce Center for Intellectual Property at the University of New Hampshire School of Law. She is so insanely cool. First, she knows a ton of stuff about intellectual property, including copyright, so we'll have that conversation. She also does a lot of stuff on gender and the law and intellectual property. She's one of the few that combines intellectual property, gender, and the law together. She's so cool. So we're psyched, really psyched to have her. Oh, goodness. All right. So this is not very long. We're just going to talk about what we should be thinking about when we think about the law and IP and gendered issues and, the world. So, so we're going to start with two questions where we start with, this is for preservation purposes. I know who you are, but can you tell me your name and where you're calling from? That's the first question.
Sure. I'm Ann Bartow, and I'm a professor of law and director of the Franklin Pierce Center for Intellectual Property at the University of New Hampshire School of Law in Concord, New Hampshire.
Very cool. And do you have any memories of anyone quilting or sewing in your life?
Oh yes, my step-great-grandmother was a quilter, and I have a beautiful quilt that she made. Of course, I keep it in my cedar chest, and I never allow anyone to touch it. I need to display it really to get more enjoyment out of it. But I treasure that very much. It's a really nice quilt. And my aunt and my grandmother, and even my mother to an extent, did knitting and crocheting and some sewing. Mm-hmm. And my aunt actually would make sewing machine quilts. Like when someone had a new baby, she liked to make the sewing machine quilts because she thought that was like a nice touch. So I also I got her hooked on, if you buy like big pieces of fleece, and then you cut the ends into fringe, and then you can tie two together and make a nice flat blanket or baby. I got her hooked on that too because the colors are so bright, and so warm and fuzzy. Oh, so that was something she liked to do with her grandkids because there's no needles or sewing. It's just tying knots. Yeah, right. So we had some fun with that.
That's so cool. And we talked when we were on our big adventure, my kid and I, and at the very beginning of this project, which was in the summer, and I can't believe how much has happened since then. So what we're looking at this project is the role of law in creativity. And what I wanted to know is what do you think we should be looking at when we're thinking about these questions, regardless of sort of what the genre is, right? It could be anything. But what do you think in terms of our field, what we should be thinking about in terms of the big questions?
Yeah, so that's actually a hard one, and interestingly enough, I've been thinking about it for a different reason, because I was trying to articulate to someone what it means to look at social justice and intellectual property, and I mean, social justice, I don't think it should be compartmentalized. Like, I think that should sort of be integrated into intellectual property, because when you think about it, justice for who raises some really complicated questions. Yeah. Like, a really good window into it in quilting, I think, is related is traditional knowledge, which can be quilting, because then it's just really hard. It's like, should it belong to the whole community, or, should it belong to individuals within the community, and how does that all play out? Like, who are we interested in?
Right. Let me break that up just in case people don't know what that means. Sure. Explain what traditional knowledge is and why there's a problem with intellectual property and traditional knowledge.
Yes. So the legal system and intellectual property within the legal system is like kind of law generally. It was like kind of created by people who have a certain view of the privileged, wealthy people, highly educated people who have a certain view of the world, and who want to turn well, actually, we go back to land even, right? Like, what does it mean to own land, and what are the ways that you can control land, or what are the ways that the community should still have access to land or water or things like that in the natural environment, and how contentious that can be, and how lawyers want to sort of figure it out with pieces of paper and fences. And so intellectual property is like that, except the fences are invisible, right? You can't see the acre of land, but intellectual property is sort of about, treating ideas and creativity like they're fungible commodities that we can have metes and bounds and organized rules and all those sorts of things. But the same issues we had with like real land, with real property, where someone actually did own it before, or the community was sharing it in a comfortable way before someone came in and said, "Oh no, we own this. We're putting up some fences, and we have this piece of paper, so our rights are superior to yours." So that whole thing happens in intellectual property. And traditional knowledge is the way it's a broad term, and it can mean a lot of things, but it's the way, say, of a community, a geographic community or a community of interest, passes on and shares knowledge, and the way that happens. And it's usually nothing at all like an organized intellectual property system, and so the two can clash. And so one thing that happens, there's something called bioprospecting, and that's where people who live in, somewhat harmony with nature, or would have natural remedies for things. Like they would know certain herbs, maybe for an upset stomach, that you could take. And then sort of people in the pharmaceutical industry would kind of go into the community, talk to people, learn that this herb was good for a stomach ache, and then they might try to actually kind of own that, to turn it into a pill, assert patent rights or some kind of intellectual property rights, and propertize it for themselves. So you can see the tension there, like they kind of stole it from the community, but the community wasn't acting like they owned it. They were acting like it was there for everyone to share. And so the community might not mind sharing it, but then if they get blocked from using the remedy that they sort of pioneered, you could see why that's kind of upsetting.
Yeah.
So, or they don't get a good cut. So, I mean, there's just a lot of competing interests. Of course, the person, the bioprospector, thinks, well, I brought this great remedy to other people who wouldn't outside the communities who didn't have it, so I did a good thing and I should be rewarded. And then the law just tries to figure out who has, the superior rights. Can we divide it? Is one person, is it winner take all? Those sorts of things. So when you bring it back to quilts, traditional knowledge might just be, people when they have teach each other quilting, figure out sort of traditional patterns and way derivatives of the patterns, how to do certain things in terms of making your quilt, stronger, heavier, prettier, so, more durable, more eye-catching, all those sorts of things. And so that would be kind of like the repertoire of traditional quilts from a certain community. And then intellectual property law then, seeks to kind of commodify and propertize the rights. So we ask questions. I mean, the assumption underlying all intellectual property is that if we have these monopolies, that incentivizes people. They get to earn one of these monopolies and then, commodify it, then use it to make money. And I think I've been to quilting shows and quilting sort of contests, quilting funds, the Kutztown Folk Festival, other things, just smaller things, through 4-H when kids do it, or just craft fairs or county fairs, those sorts of things where quilting or needlework are part of it. And, those people want to win. So they want to win a prize. And to do that, they do push themselves, I think, to be more original. And that's a good thing because it kind of advances quilting. But then the question is, how much power do we want to give them? Like, should they have power only over their unique quilt? And if somebody, likes it and wants to do one like it, is that okay as long as it's not identical? Is it okay if it's identical? Or is there some sort of scope of protection the innovator ought to have? So They're all really hard questions.
Yeah, they really are hard questions. And it's interesting because we'll be doing more work on this summer. I think about like the pool of resources that we have with quilting, that we have blocks that we've named that everybody knows, which is really interesting. And that feels like traditional knowledge. Then we have guilds that everybody makes a block and contributes it. So that's really interesting too, in terms of we don't usually think of, who is the author? Does it matter? And then the last part of it is, for me, is this like, intellectual property, as you well know, is a economic system. So when you have people who are not doing it for economic purposes, and there are people who are doing it for economic purposes. It's that same tension between traditional knowledge and traditional intellectual property protection that I think that we see in the quilting industry. I don't know. We'll see. Yeah. That's interesting. Well, we're going to have a lot of questions as we go. Also, you're in the middle of
Good.
a lot of quilting things happen within your world. So like you're in like quilting heaven in some ways. You have Vermont Quilt Festival up there.
Hampshire, yeah. Vermont, sure. Yeah. And it's, it's a cold climate, so warm blankets are always, really, so one of the derivations of quilts is just to kind of, recycle, right? You take clothes that were completely worn out, cut them into pieces, and sew a warm blanket out of it. So in some respects, initially, probably didn't really care what it looked like.
Yeah.
As long as it was warm, but at some point, so what could be warm and it could be attractive.
Exactly.
And, kind of the birth of the quilting industry here. Although I think all cultures have something like quilting, don't they? Where they do that, they recycle old fabric, stuff. New things.
We would think. I don't know the answer to that. That's a good question to be researching. Now, so we have Stars Athletica and Useful Articles Doctrine and all kinds of things that I don't think really impacts quilts that much. So an aesthetic separability and doctrine of functionality, all these fancy words, which basically means explain like what the worry is, like what parts of a quilt get protected by copyright and what parts don't get protected by copyright.
Yeah. So I guess in a way I kind of agree with you because I don't see quilts as all that complicated in terms of that question, because I think I would look at a quilt just like I look at a painting, right, or a print, where you say it doesn't have to be all that creative to be, like we say in copyright, a scintilla of originality is enough. So it doesn't have to be created to get the copyright. So if copyright's a yes or no question, I think that's easy with most quilts, right? Most of them are going to be a yes. Maybe just some would be a no. But most of them would be a yes, even if it was just like 4 big blocks with a certain kind of color scheme. Paintings are like that. Paintings like that sell for millions of dollars sometimes.
Right.
So presumably,
the bar for copyright is really low. It's just like a little bit of creativity, like tiny bit of creativity, enough that, there's no aesthetic. It doesn't have to be perfect or pretty or important. Yeah, right. Aesthetic non-discrimination. We don't care what it looks like. Yeah. It still gets protected.
Right.
Yeah.
Yeah. So it's a yes or no question. I think quilts are easy, but what gets more complicated is the scope of the copyright.
Yeah.
If somebody is asserting rights over their quilt, how far does that go? Now, the other thing that is actually important, I think, in quilting is independent origination, because there are basic patterns that I don't think it's actually would be that surprising to me if two people came up with a pretty close to identical quilt.
Yeah.
Right? If they were just following if they were doing a certain size quilt, the same size, and a certain pattern, and they happen to choose the same color scheme, I don't think we would find that remarkable. And copyright allows for that, so they can both have a copyright.
Yeah.
It's more powerful. The image of that is more powerful with photographs, right? Like a lot of people, if you go to some kind of landmark, will take basically identical pictures from each other because they all are pointing the camera at the same thing from approximately the same place, so it doesn't surprise us. And somehow we handle that. Copyright handles that. They just give a very thin scope of copyright to photograph those kinds of photographs. And some courts would even say really only literal copying is infringement. Like the scope is so thin. With quilts, I don't think we would get that. I'm sorry.
Yeah, so let's go back to those. So it's thin copyright. What does thin copyright, for people who don't understand, what does thin copyright mean?
Thin copyright just means that the scope isn't that extensive. So if you came up with an oil painting that was really, really, colorful and had a lot going on and was really original, then we might say, because there's so many original things going on, that if another painter was set out to copy your painting, we would let them be inspired by your painting, or maybe paint with your style, but as they creep closer and closer to being identical to your painting, copyright would kind of cut them off in the substantial similarity zone, right? We wouldn't say everything's okay up to an identical copy. We might say up until a certain point where it's starting to look substantially similar. So that would be a more robust copyright. On things that are really simple, like again, if and my law school is a beautiful building, if you can take a very pretty, it's a nice brick building, nice natural environment, you can take a picture of the front of the building, and basically everyone takes the same picture because it just looks really nice from a certain vantage point across the street. And so I don't know, hundreds of, maybe tens of thousands of pictures, probably all about the same, but we don't want a copyright to get in the way of that. We want people to be able to take their own pictures. So we say, if you take your own picture, you're okay.